So how do you decide which cases should be reviewed?
Well, what happens currently is we receive requests from, as I said earlier, a lot of different sources. Some cases come directly from the defendants. They'll write from prison. I had one case where a defendant's mom came to see me. We have attorneys will contact us. So there's really no magical way that the case gets brought to our attention. What we do is initially the cases all come to me initially, and there's an assistant in our civil division actually that comes from out of county. That was one of my first hires that has really no history with the office, and she helps look at some of these cases initially. So there's an initial screening because we want to make sure that there's really a claim of actual innocence, because we have to respect the jury's decision. I think everybody that is in prison would probably tell you they're innocent, just about all of them. So we have to make sure we're not clouding the real cases that need to be looked at. So we'll look at cases initially to make sure that there's some evidence of actual innocence. They're not, if they have issues procedurally in their trial, or they thought their sentence was unfair, things like that. I'm not trying to circumvent the appeals process or the post-conviction process. There's a process for that. So we'll screen those cases, and then if there is an issue with actual innocence, where somebody feels that there's new evidence that a jury didn't hear before, what will happen then is I will give that case to the panel. In anything that the defendant or their attorney writes, any correspondence in terms of sort of their side of the story, we give all that to the panel as well, individually. So they will individually review that, and then they will individually have questions about things they'd like to see in the file. We don't automatically give the entire file to every member of the panel. And one of the main reasons for that is sometimes these files are 20 years old and they're in 10 banker's boxes full of stuff. So we'll give them the outline, we'll give them whatever the defendant has, we'll give them that, and then they'll have questions. Hey, I'd like to see the transcripts from the closing arguments, or I'd like to see this medical record, or I'd like to see these reports. And then as those requests come in, we'll give that to everybody on the panel. Then we'll meet as a group and we'll discuss it as a group. People will bring out questions they have, and then there's always follow-up that then we'll do. And sometimes I'm lucky enough to have an intern that helps with some of that. And then there's kind of a back and forth. And all along, we're also working with, if it's always easier if there's an attorney on the other side. So we always encourage the family to get an attorney. And so we'll be working with the attorney as well. And sometimes there's requests made. There's been cases where it's come in, the panel has looked at it. There hasn't really been anything additional. I've looked at it and said, really, there's nothing new here, so we're essentially not going to look at this case anymore. And then after that, an attorney has contacted me and said, hey, well, we have some new information. Then we've looked at it again, because the most critical thing here, above all this, is you have to keep an open mind as a prosecutor. You never want to get to the point where you say, well, they've been convicted and that's that. So, especially when you're talking about cases that are 20 years old, when there just wasn't the science then that there is now. So as long as we're keeping an open mind to stuff, at the same time being respectful of the jury process, I think we're doing our job. But it's never easy. I mean, I think the cases where you're going to get a very clear-cut yes or no, those are very rare. And as we move into the future, those are going to become less and less. The tough ones are where you get evidence coming back that doesn't really tell you one way or the other. And then what do you do? And what's very difficult for us is, you essentially have a situation where you have, because these are almost all murder cases, you have either a murderer that you're going to potentially let loose, or you have an innocent person that's convicted. Both are horrible situations. So it's definitely not an easy thing, but you can't. It's not something that can be ignored. So.
Is there a specific criteria that cases must meet?
The criteria that I have is there just has to be something new. There has to be, it has to be actual innocence, and there has to be something new. I've had few cases come in where people have sort of wanted to essentially rehash the argument they made to the jury, and again, I'm not in the God playing business. So if a jury heard this and they heard this and they go this way, we have a jury system. So we do see that somewhat frequently, where, in particular, where you have expert witnesses, where the jury will hear one expert and another, and then the defense they'll believe the prosecutor's expert and convict, and then the defense will say, "Well, I want you to look at our expert again."
Mm-hmm.
Well, if there's nothing new, I'm generally not going to overturn that because, again, I'm not God. So that's the jury's decision, and I respect it.
Mm-hmm. So then, what would it take for a case to be overturned?
I would have to be convinced that the person's actually innocent because, again, if I'm wrong on something like that, I'm essentially putting a killer on the streets, and I have a responsibility not to do that.
Right.
And as I said earlier, that's why these are very difficult cases, almost always. I mean, if there's ever a case where it's very clearly not the person, and the cases really that started this thing, the 4 cases in Lake County, those were pretty clear-cut cases where you had DNA that came back very clearly showing it wasn't the person, and those are easy. Awful situations because you never want to see somebody. There was one case where a man was in jail for 5 years waiting for trial, and eventually this office determined prior to me being elected that it was somebody else involved, and he sat in jail for 5 years. So that's an awful thing. But those cases, it was when the DNA came back, it was pretty clear cut.
Right.
And as I said, I think as we move into the future, as we do more and more DNA testing, those cases are going to be fewer. And the cases where it's not always as clear, you're going to see a lot of those. And those are tough.
Right.
So you just have to weigh what you get. And if there's new evidence that does indicate that somebody's innocent, obviously we're going to get them out of prison right away. And nobody, I hope nobody in law enforcement wants innocent people. Yeah. You do have bad apples, certainly. But the vast majority of police officers, vast majority of prosecutors are really trying to get it right. They really believe they have the right people. Nobody wants to convict an innocent person because you've convicted somebody innocently, which is awful, and you've also let the real person go free, and that's not something anybody wants.